believe that there was a motion to continue the status conference, and that matter was continued. So I think the only reason we're here this morning is to argue the Rule 37 discovery issue. Am I correct on that?
I believe so, Your Honor. I think we have two issues to argue before the court today, both of which are related to discovery.
Okay. So the one matter I understand, at least that's on the court's calendar today, is the subpoena to Dr. Taylor and the objection. I believe that's one matter. Is that correct?
That's my understanding of it, Your Honor. I was not aware that I didn't know that we weren't doing a status conference, but the court can, I'm not objecting to that. It's the court's calendar.
I just saw that it was on the calendar. What's the other matter that we're...
Well, I think you said Dr. Taylor, and my understanding is that issue's been resolved, that the court's already ruled on that issue.
Well, I think what happened is there was an objection following my ruling asking for reconsideration, so we're here. I'm happy to hear that today. I'm not going to take a long time on it, but I'm happy to hear arguments on that.
The two issues that I'm aware of, and apparently it sounds like there might be three, is we issued a subpoena to Dr. Livingstone, who acted as a custody evaluator in this case, requesting his underlying data for his opinion. He sent us a letter telling us he wasn't going to do that, and before we had a chance to bring the matter into the court ourselves, counsel filed an objection and attached his letter to it. So we're here on that objection to our subpoena for Dr. Livingstone's underlying data. We are also here on counsel's objection to our subpoenas to financial institutions to obtain account information for respondent.
And that's numerous financial institutions, right?
Various financial institutions, yes, Your Honor. So, whichever order you'd like to take those in, I probably am not very prepared on the Dr. Taylor issue, but if you want to have us argue that, I'll do my best.
All right.
Well,
let me just say this. Let me ask Ms. Blakelock, let me just tell you where I'm at on that Taylor subpoena issue and your objection, and then I'll let you make whatever argument you would like to, and I'll ask counsel to respond. So I looked in the docket, and there is a previous court order by Judge Lowe that was issued on November 8th, I think you indicated the 18th, 2016, where the court ordered Dr. Taylor to provide information that he had given to Dr. Livingston and denied the protective order in that case. That's the first thing that I notice is relevant to the subpoena to Dr. Taylor. So it's already really been ordered by Judge Lowe, and I think it's the same material that we're talking about, and that is material that he provided to Dr. Livingston that was not provided in the subpoena that was sent to him following that order. And then there was a second statement requesting an order compelling Dr. Taylor to provide that information, and he made some arguments about good faith, that it should be in person, etc. The problem with those arguments that I have is it's already been ordered by Judge Lowe. So even if I said that petitioners did not comply with that rule, that discovery rule, which I think the court can find that they did. It doesn't. The problem is we have a standing order of the court saying provide it. And so I'd be overruling the court's previous order to provide that information to counsel. And so my inclination is that to deny your objection based on that previous order, and it seems to me also that this is information that's needed. We can certainly issue a protective order that it's not disseminated anywhere except with counsel and his client. And so I don't see any reason why it cannot be provided. Go ahead.
Your Honor, the reason is because it was improperly obtained. The number one, the rules absolutely require that I be given notice, and in my objections, I attached a copy of the letter to Dr. Taylor that was, for example, the letter written on January 9th, and as well as the envelope, and that was called the meet and confer letter. It was not given to me. It was not copied to me, and meet and confer is not under the statute allowed to be. 37A2B says a certification that the party has met in good faith has to be done by phone or in person. It cannot be a letter. But it also says that the certification has to be an attempt to confer with other affected parties. There's no party more affected than the respondent who was the subject of this. And so whether or not the order was issued is sort of, I agree with you, it's water under the bridge. They've got the documents, but it affects a great deal because it affects their ability to use it at court, to use it during trial. They have it, and what I referred to in my objection was I filed my objection on February, regarding the letter they wrote January 9th. And certainly when they wrote the letter January 9th, they didn't confer with me. In fact, I just found out this morning, and if this is so, I will follow it up later, but there might be even other documents and subpoenas that have gone out to other parties that haven't been filed with the court or I haven't given notice of. But I was certainly not given notice of this. And
so let me interrupt you for a minute. But, I mean, I would think that Rule 26, would apply but for this order. I mean, they're acting pursuant to the order that says the court ordered Dr. Tater compelled to comply with this subpoena. Now,
I'm not talking about your order.
Rule 26, in my opinion, because it no longer applies. We're not operating under Rule 26. We're operating under an order that was issued by the court for Dr. Taylor to comply with that subpoena. So I don't see how Rule 26 applies. Go ahead.
Well, it applies in that you can restrain them from using it, and if the underlying basis on which the court was entered, they stated to the court, they submitted a proposed order in which they affirmed with this court that they met and conferred. That's the basis of the order issuing. If they didn't comply with the rule, the order couldn't have been issued. So while it may have been issued, it certainly wasn't properly issued, and in a timely manner, I brought that to the court's attention. And I'm sure Judge Lowe assumed that meet and confer had been complied with. It hadn't. In addition to that, I cited to the court that none of this, if we're going to speak of orders, the first order that was signed and the first order of which we're under effect is Judge Lowe's order from November of 2015, which prevented them from doing this in the first place. And when we had the hearing before Commissioner in November of 2015, he stated that he wanted the substance of his order specific. They objected to that order. Judge Lowe heard it. Judge Lowe heard all the evidence. Judge Lowe read the transcript. And Judge Lowe issued an order in 2015 that said no more discovery. It all goes to the evaluator. And after that, if you want anything, you have to come before the court. And I cited to those paragraphs in the court. The hearing, November 19th, 2015. The court went at paragraphs 26, 30, 33, 34, and 35 that put specific restrictions on the restraint for getting information, medical information. And then
doesn't his subsequent order in November of 2016?
15.
You're talking about the 2015 order, yeah, I understand that.
Okay, and
But then he issued a second order compelling Dr. Taylor, and to me, that order supersedes his prior order.
well, it would if it was done on a proper basis. My argument to the court is that if they weren't honest in their order and if they didn't comply with Rule 37, how can it be a valid order? Because the court issued it assuming that they had complied.
Your Honor, if I can just...
And in the middle of a sentence, sir.
Let's do this. Let her finish, and then I'll allow you to...
I just want to lodge a standing objection. There is no 60B motion in front of the court to set aside any prior order of the court.
Right. Thank you. Go ahead.
Didn't do it under 60B. They issued, I've got a copy of the transcript here. Judge, there was an order.
I think what he's saying that there was no motion under Rule 60B to overturn that November 8th order of 2016. I think that's what he's arguing.
There is no motion before the court. That's my objection.
Now to my ruling, I think, is what's before the court.
Yeah.
There was an order issued February 3rd, 2017 on second order, on second statement of discovery issues, Dr. Taylor. Certainly, my objection that was filed in January goes to an order, the second order then. Assume the first order's, even my arguments are correct, I suppose, but you're saying, okay, even if you're correct, it doesn't count because the order was signed and entered. Putting that aside.
The superseding order that occurred after the order that you're discussing in 2015.
Correct.
By Judge Law.
Correct. Now there's an order issued in February under the same basis. And that order is February 3rd, 2017. That order states that Judge Taylor, same judge, Judge Taylor shall immediately comply with the requirements of the October 10th, 2016 order.
You mean Dr. Taylor?
Excuse me, I apologize. John Taylor, MD, that was served on him, and as reiterated by the letter from counsel dated January 9th. Before this order was signed, I filed an objection that is the subject of today's hearings, an argument, stating objection, and my objection was entitled, Objection to Order of Second Statement. The issue is...
And I consider that, and that's why we're here today, and I'm allowed to argue.
But I'm not arguing the first one, Your Honor. They're conflating the issues. My objection is specifically to the second one. Objection to second statement of discovery issues. If their second statement of discovery issues that they wrote down, the first order you're referring to was signed in November 18th. That's the first order. Then, on November 18th, the first order was signed. I so recite that at paragraph 7 of the facts. But the second order, which I'm specifically, I suppose appropriately here, the reason to uphold the second order isn't because the first one might have been wrong, that it was already the first one, because we've already had that argument regarding the November 2015 order. This order says that Dr. Taylor shall comply. He shall do it in the next 5 days. And on their second motion with their second order, and my objection to it was specifically, and if you will look at attachment to the order, attachment 2, as well as the envelope, you will see that I was not copied on that order. My client was affected by that order. It isn't appropriate, and arguing that they had the first order can't bootstrap in bad behavior and inappropriate behavior on the second order. There was no proper certification. I was not notified, and they're required to confer. They didn't. And Dr. Taylor was notified, but my client is the affected party. And stating that it happened before, so therefore the second order should stand, is not an argument. It isn't even an argument in good faith. They didn't comply with Rule 26C. All discovery in this case is long since closed. So the fact that the first order was signed is irrelevant if discovery was closed. And you have to ask to continue discovery before it closes. You can't ask after it's closed. So I'm not understanding the argument that if they slipped it in when they shouldn't have, they can still do it. That's the argument. And my objection was to the second one. It was filed before and in a timely manner. There was absolutely no meet and confer. There isn't even a claim that there was. My client was the affected party. And I don't see that the second order can stand, which if it cannot stand, it questions how can they then use it in court, because that's the substance of the second order.
I have one fact question. Did you object to that original order that was issued by Judge Lowe?
I objected, but I objected after he signed it, I think. So I don't think, let me check the docket and I'll tell you the answer. But I think I recall they filed it. They filed the notice of issuance on subpoena on 10/10. And then that's when I first knew about it, October 10th. And then on October 12th, I filed a motion for protective order. On November 18th, it was signed. So I
He denied your protective order. I saw that. And then granted.
Okay, he signed it. But I asked for oral arguments. It wasn't granted. And then came the second one. When the second one came, I asked for a hearing. Hearing was granted. And it still doesn't make it proper when you don't comply with the rules. And the underlying issue is if discovery's closed, how could they do it at all? Well, they've got an order, and I suppose that's subject for appeal, and not here, but I don't see how an order can issue allowing discovery if no motion was made to extend discovery past the date when it was closed. Discovery was closed when they did it.
You mean when the court ordered your protective order, when it denied that order?
Well, they didn't deny the protective order. He just signed their proposed order, which is different.
No, he denied your protective order in the ruling.
Well, in the court docket, it says order on...
the ruling of November, Judge Lowe did two things. He ordered that Dr. Taylor comply, and he also denied your request for protective order and your objection.
The order that was signed didn't mention that. The order signed November 18th. It says order on discovery issues. Number 1, respondent's objection to subpoena duces tecum is overruled. Petitioner is entitled to use it. In the case, petitioner may seek additional documents. That's the order. It didn't reference the protective order. This was proposed by the court and filed with the court the 11th of November. So there was no separate ruling in the court docket. And the order, I'm looking at the order, if the judge might have made a minute entry that I didn't have access to. But on 11/18, he signed the order, and then they did another statement of discovery issues. And we had a hearing on October 11th where these things were not discussed, and instead he set it to the January hearing where you Your Honor, appeared. By that time things had switched around. And then at the January 10th hearing, no, there was no argument on it because it was just a status conference. And at that, on January 10th, you sent oral arguments for today's date. So Judge Lowe signed the proposed order that was submitted to him on November 11th. But by November 11th, the documents had already been produced by Judge Taylor. The whole file had been produced without notice to me because they didn't contact me. They didn't send me a letter. They didn't confer with me. Then they filed the second notice of discovery issues, which left me out of the loop as well, and my client. And that's the proof I did attach from their January 9th, 2017 hearing. So, okay, they did it twice. But certainly on the second time, the first time I made objection, Judge Lowe did what he did. But there was no separate ruling. The proposed order was just signed. And certainly on the second one, it's clear that I was on time. I was on time the first one, but overruled. And on the second one, I don't know how you get past the requirements of Rule 37 that say you have to do meet and confer, it has to be in person or by phone, cannot be by letter, and it has to be with the affected persons. And see Exhibit Attachment 2, where I was left out of the loop once again. And it just references an October subpoena, and then it gives him more instructions. And I also copied to the court the envelope, because I didn't get one.
I'm looking at the order right now. It was issued by Judge Lowe on November 18, 2016, and the court did three things. The court hereby orders that respondent's objection to the subpoena ducis tecum is overruled, and that her motion for a protective order is denied. That's the first thing he did. Second thing is the petitioner is entitled to use in the course of the litigation of this case the documents that have already been produced to counsel by John Taylor. That issue is ruled on. Third, petitioner may also seek any additional documents that were not included in the documents produced by Dr. Taylor, but that should have been produced. And petitioner may have all of the documents so obtained examined by his expert. That's what the court ordered, three things.
Yes, I'm agreeing with you.
Well, you said he didn't deny your protective order. He did deny that protective order.
I'm saying he issued this, but not any separate ruling. I'm saying that an order is different from, I was just making a distinction between the two. Right. I'm not disagreeing with the order. I'm saying he didn't issue a ruling and then the order was drafted. He signed the proposed order. So there is a difference, but maybe without a purpose, but there is a distinction. And what I'm stating is, if discovery was closed when this occurred, there was no order reopening it. So the order, in effect, was an order that was issued after discovery was closed when no order opened it.
But what you're arguing to me is you want me to go back a year and overturn that order when you didn't appeal it, you didn't file an objection to it afterwards, and I don't think I can do that. And I think I can't go back and second guess him a year earlier and determine what it was that he considered and ruled that he was wrong.
I'm not saying he was wrong.
That's something for an appellate court, but not for this court.
I agree with that, Your Honor. And I'm not saying he was wrong. It is, he said what he said. What I'm stating to you is that my objection for today is as we described on the second statement. And I objected to that, and then that one clearly is one that I filed on time. And you can change your order, you can keep it the same, but I agree it's an appellate court issue. It's an interlocutory appeal issue, but I'll submit it with that.
I don't think I can hear any further argument. I'm sorry that I disagree with some of your argument that I don't think the Rule 26 applies here in this argument to my current order, because I ruled based on looking at the docket that back in November, Judge Lowe had ruled that your protective order was denied and allowed and ordered that counsel be allowed to subpoena and get information from Dr. Taylor. Really, what my order did was just confirm that earlier ruling by Judge Lowe. And so I'm overruling your objection. The order stands. And the order stands because Judge Lowe ruled that exact same thing a year ago. And so that'll be the ruling of the court. Let's proceed to the other. I think we've got three other issues you mentioned. I wrote them down. One is
by my count, we've only got two left.
all right. One's the subpoena to Dr. Livingston, and the other one is the objection to the subpoenas to the banks. Is that correct?
Those are the two issues that
All
I'm
right.
aware of, Your Honor. I don't know who you'd like to go first. We issued the subpoenas, counsel objected to them.
On the issue to Dr. Livingston, I think procedurally, Dr. Livingston's entitled to be noticed up since we're arguing his refusal, but if you want to go forward without him, okay.
So, help me understand this. My thinking is this is a subpoena, a trial subpoena. Subpoena duces tecum, requesting that he provide documents so that you can use those at trial. Is that correct?
That is correct, Your Honor. We're looking for the underlying data that he based his opinion on when we met with him in September of last year. Under Rule 702, before his opinion can be introduced at trial, it has to be demonstrated that it's based on sufficient facts or data, and we're concerned that it's not. So that's why we've requested that, because we anticipate that counsel will call him at trial, and we need to be prepared to help the court decide whether he can act as an expert with respect to this particular issue. And I think that we're frankly entitled to that information. It's the same underlying theme that Judge Lowe ruled on with respect to Dr. Taylor, who provided information to Dr. Livingston, which is just a continuation of getting the underlying data with respect to the opinion that we anticipate he will provide at trial based on the meeting that we had with him and counsel in September. So these issues are all really quite fresh, and I'm not sure what else the court would like to know with respect to that.
Let's start with just that issue before we go on to the bank issue. Why are they not entitled to issue a subpoena so they can be prepared? He is an expert witness.
He is, Your Honor, but he's not allowed to give them, and counsel knows that very well. The raw data cannot be supplied to anybody except it could go only to from Dr. And by the rules under which Dr. Livingston operates, he cannot do it. He cannot release them. He can release them to another qualified PhD to look at them, but they're not asking for records like medical records. They're asking for raw data. Raw data is subject to interpretation and can only go from expert to expert. They've not appointed any expert who's qualified to examine the data. But Dr. Livingston probably would like his attorney to explain that. He's entitled to an attorney under the rules and to a hearing in that regard. His letter...
If this were an order should cause, I think what I have to rule on first is whether or not he needs to respond to the subpoena. If he doesn't, if he refuses to,
no, he can't.
Then we would do an order to show cause. We can argue those things. And I think you're right. He would need to be here at that order to show cause if he refuses to comply with the subpoena.
The distinction is important in this case, Your Honor. He cannot release them. And so he's under the rules. He cannot release them. He explained that to us both in person, and then he wrote a letter stating that he cannot release them. He'd lose his license if he released them. The raw data can be released, but it has to be released in a proper manner, and the order has to protect it. I can't look at...
Let me ask you about this. How do we comply with the rule? And I read your motion and looked at that rule, but at the same time allow you to prepare for his expert testimony during trial? Because I think it would be unfair if he were to come and testify without allowing the respondent to look at all that information to prepare for his testimony. And so how can we issue a protective order to protect all that information, or as you're suggesting, the rule apparently indicates that it should be provided to another psychologist or another expert. Can that expert then disclose all that information to counsel?
Well, the expert can look at it, but the parties are never to see it. That's part of the rules. And counsel can then discuss with his expert. I'm married to mine. My husband's a licensed psychologist who does custody evaluations. If he gets raw data, he explains it to me to see if there was any mistakes. The data's the data. But it cannot go to counsel. And so when you subpoena it, you have to subpoena it, and then you subpoena it to go to Dr. Jones or somebody qualified to look at it. But he can't just ask that it go to him. That's the problem. And the other second problem is, he said he can act as so that they can determine if Dr. Livingstone can act as an expert.
Remind me the rule, counsel, the number of the rule.
Oh, I don't know if I have that in front of me. Let me look. But Dr. Livingstone is the expert. He is the petitioner's expert. So he's challenging his own expert.
All right, let me hear from opposing counsel on why we should require that rule complied with.
Thank you, Your Honor. First of all, we have not called Dr. Livingstone as our expert, nor do we intend to. Okay. He's not our expert. If anybody calls him as an expert, it's going to be responding. Now, I don't know what rule counsel is talking about. I have not seen, to my recollection, a rule that disallows an expert witness, potential expert witness, such as Dr. Livingstone, from supplying the underlying facts and data to the other side, which we obviously need in order to prepare for trial. I'm not aware of any rule. I don't think one's been cited. There's not a court rule on that, to my knowledge. There is, however, a court rule that says that a showing has to be made that he's basing his opinion on sufficient facts and data, which very clearly makes that relevant to us under Rule 26. And quite frankly, to my knowledge, these types of subpoenas and issues are routinely granted in favor of the person seeking the discovery, which is sort of the underlying theme here. We're seeking discovery, trying to get this case in order and figure out what to do with it and move it forward. And at every turn, all we're met with is obstruction. So, are there reasonable constraints that might be put on the underlying facts and data? Sure. But does counsel get to see them? Absolutely. And we can share them with our experts, retained experts, either somebody who's just helping us prepare for trial, for cross-examination, or a rebuttal expert that we may want to bring. So I'm just not seeing this. I'm not aware of a rule that prohibits it. I haven't seen one cited to my recollection, and I don't know why we ought not be entitled to those underlying facts and data of what appears to be an opposing expert. To me, it's kind of an easy issue. There's nothing difficult about it. I am unaware of any rule that says that can only be disclosed to some other expert. I know that Dr. Livingstone, in his letter, which has been provided through counsel in her objection, seems to be of that opinion. But as I recall, he thought he was basing his opinion on some court order, which doesn't exist. So, and I think he's quite frankly just simply mistaken.
Well, Your Honor, I've been doing this almost 30 years, and I can tell you he's not mistaken. I direct the court to the court minutes of 428:15 when we had a hearing on the subject of petitioner's motion for custody evaluation. And I was directed by the court to answer their motion for custody evaluation within 10 days. And if you will look on the court docket, 428:15, because they filed a motion for custody evaluator, it came before oral arguments. Commissioner Patton said, no, you can't do it. I want to see your written response to their motion for a custody evaluator. On 5/1, I filed a reply response, and it went forward. But it says, Ms. Blakelock is directed to answer the motion for custody evaluation within 10 days. Then following that, the judge ordered various things in the order. I don't have it here. But then there was an order for the custody evaluation, and the order of 2015 might in fact have dicta in there about which party ordered it. The father in this case filed a motion a petition to change custody. Why would the mother be the one who said, oh, I want a custody evaluation? She hasn't even...
Was Dr. Livingston appointed as the person to conduct the study?
No, he was not.
The evaluation?
He was not, Your Honor. It was Dr. Featherstone who died.
That's correct. And then Livingstone took his place. But that...
Livingstone never was appointed to take his place, but he did perform a custody evaluation in connection with the issues in this case.
Well, then that goes in direct contradiction to what the order says.
I'm not sure of the relevance of this argument, quite frankly. We don't intend to call Dr. Livingstone as our witness. At best, he's a court-appointed custody evaluator, not our expert. We did bring a motion for a court-appointed custody evaluator, but...
And that was Dr. Featherstone?
Dr. Featherstone was appointed.
This is a long record. How did Dr. Livingston take over the responsibility of doing the custody evaluation?
Featherstone died, and then they asked for Livingstone. That's the answer.
Well, I don't recall that we asked for him.
Well, we didn't ask for custody evaluator. They did. So how would it be that the responding party, that would be her demand?
So this is a pretty simple question, and I'm not getting a direct answer, and that is, was Livingstone never appointed by the court to be the custody evaluator?
That is correct, Your Honor.
Would he just take that over by...
And even if he had been, the order that appointed, even if he had stepped right into Dr. Featherstone's shoes, there's nothing in the order that appointed Dr. Featherstone that said we would not be entitled to get his underlying facts and data if we had a problem with what it appeared his opinion was going to be.
Yeah. I didn't see, and I tried the best as I can to go through this long record, any order appointing Dr. Livingstone to be a custody evaluator in this case. I haven't found it anywhere. So he certainly wasn't authorized, that I can see, by the court to conduct that evaluation. And those rules, and I think it's rule, I was trying to find it. I know that I've read, counsel, that you cited a couple of rules, but I don't think they apply if he wasn't appointed by the court. And that's what the assumption that he seems to make in his letter. And so maybe I need to go back, find the rule, read it carefully, and I'll just have to take this under advisement, because I think it turns on that. If he was appointed by the court, then he could rely on that rule. And I'm new to divorce, I'll acknowledge that right away. I'm going to have to go research this.
I think you're talking about 4903 of the Code of Judicial Administration, I think.
That's not
even a review of those rules don't restrict our ability to get his underlying facts and data. Even if he had been properly appointed by the court to step into Dr. Featherstone's shoes, I'm not aware of a rule that prevents us from getting his underlying facts and data. If the court wants to take it under advisement, certainly that's the court's prerogative. We'd be happy to supplement the briefing on that issue if the court thinks that might be helpful.
And I agree to that as well. One of the problems then there, I suppose they have, is if they're claiming Dr. Livingstone isn't their expert, and they paid him, and they disagree with him, and there is no custody evaluator appointed, and the matter's been pending 3 years on a petition to modify, then that seems troublesome.
All right, I'm going to take that matter under advisement. I want to look at the rule that was cited in one of them. I know I saw one of you cite. I'm surprised you can't, because you cited it in your motion, counsel. You cited it, the rule in your motion. I'm surprised you can't tell me what rule it is that...
Well, Your Honor, when you get close to 70, you're a ways off. I just forget the rule. But I will be happy to supply the court with it, and I'll remember it on the way home in my drive. But I'm just telling you, I have the rule.
All right,
I'll pull it up.
The rule, I think that's pivotal. If the rule applies, I'll issue a memorandum order on this particular issue. Now let's move to the issue regarding subpoenas to the financial institutions.
Thank you, Your Honor.
Yes.
And this is all connected to the same issue, and it goes to underlying data and sufficiency of facts and data and so forth with respect to the primary concern that the petitioner has, and that's with respect to the potential for substance abuse by the respondent and the effect that that may have on the minor children. We became aware 2 or 3 months ago that in March of 2016, respondent filed for bankruptcy.
Objection relevance?
I'll get there.
Well, this is a proper,
Well, I've not, now you're going to ask me to respond again. I can't even remember something apparently when I had the order in front of me, but I don't want to see documents that I've just been handed to on bankruptcy when the issue, there's no financial issues before the court. And now he's arguing bankruptcy.
well, he's talking about the subpoena to the financial and why they're subpoenaing that information. I think that's what he's arguing.
That's exactly right, Your Honor.
Well, it might be exactly right, but that doesn't mean he can throw me over a document I've never seen before and then argue on it.
Let's let him finish his argument, and then I'll allow you to argue, counsel.
May I approach?
Yes.
Objection is to looking at documents that I have not seen or heard of before this minute.
Now, the divorce decree in this case, Your Honor, left, to our knowledge, left the respondent with a fully paid for house, a fully paid for car, and no consumer debt. And that was entered in December of 2013. By March of 2016, she's filing bankruptcy. And I direct the court's attention to the column of figures on the right hand of the front page there. That's all we really, I think, are going to refer to.
Same objection.
About 2/3 of the way down. This is the official Form 106S for summary. It's a summary of assets and liabilities with respect to the bankruptcy case. About 2/3 of the way down in that right-hand column, there's an item called your total liabilities. There's $187,000 of total liabilities included in this bankruptcy. And we are very concerned as to how someone with a paid-off house, a paid-off car, and no consumer debt has, in slightly over 2 years, $187,000. Our concern, and why we have issued these subpoenas to the financial institutions, is to see if there's evidence of significant cash withdrawals that might have been used to buy drugs, prescription or otherwise. That's our concern. That's why we want to see it. It's very relevant. If we find nothing, great, we find nothing. On the other hand, if what we find is a bunch of transactions that are to cash or easily convertible into cash, then we have a relevant piece of evidence to produce to the court on the primary issue that is involved in this case. I could continue with what other evidence we have with respect to the possibility of substance abuse, but I think that's sufficient to show the relevance of what we're trying to do here. And this is a matter that just was never disclosed to us. We just discovered this on our own 2 or 3 months ago, and again, it goes to the underlying issue. And I could go back and talk about the prior history of the case and so forth, but I think that's enough to show the relevance to the issue. And one other factor that should have been considered by an expert, and should be considered by the court, and that's why we want it.
Ms. Blake, let me ask you this. It appears to me that what is happening is that this isn't request of discovery from you. This is on their own. They're seeking information from financial institutions by issuing subpoenas. so that the subpoena duces tecum, so that the financial institutions can respond and provide that information, so they can use it and call them if they desire to call them to raise this issue at trial. And at trial, if you object to the relevance of it, I can consider that and deny it its introduction, but I don't understand why I should deny them the opportunity to subpoena this information, and then they can try to introduce it in trial, and I can either reject the information and deny its admittance, or grant as I choose based on your objection or non-objection.
Well, I
don't understand why I should stop the process at this point, why I should prevent them from getting information they're certainly entitled to get.
No, one, discovery's closed. Two,
this isn't a request to you for discovery. It's a subpoena.
It's closed, Your Honor. I can't tell you any more than discovery is closed, including subpoenas. The rules apply or they don't. If the court's going to open it up, you're the court, obviously you can do that.
If it's newly discovered information, I can open that up for discovery. And it seems to me that that's what this is.
And I suppose, it's not an argument. You get to rule. I'm telling you why I don't agree. I don't agree because the discovery's closed. Newly discovered information is not, they discovered it, but they didn't motion to amend their pleadings. Their pleadings have nothing to do with this issue. It's not part of their petition to modify. So they're trying to discover an issue that is not part of their petition to modify. If you open it up, then you open it up because they've made the case that my client should file a counterclaim for alimony. I guess we can keep litigating as long as we want. But they have to follow the procedures. The procedures are that discovery is closed. If they're going to let them do this, then you need to allow both sides to do it. I get to do discovery, and if what I found out this morning happened, then I'm going to set a sanctions hearing because apparently they're trying to discover and subpoenaing information that's not been filed in the court file and to third parties that is not related to my client's accounts. So if you want to open it up, then I guess I would only ask that you be fair and open it up and we'll make a counterclaim. But my argument is it's completely unfair to my client to allow them to have little bits where they want to because they think they've got something discovered, and I'm following the rules over here. If it's open, it's open. If it's closed, it's closed. But if it's open, and the evaluator now isn't even the evaluator, then at least set the rules so I know what they are, because I thought discovery's closed. It's not closed? Okay, it's open. I'm okay. I do fine if it goes on. But I object to my following the rules and adhering to them exactly. Well, the other side newly discovers stuff, doesn't petition, doesn't motion to amend, doesn't clean up the case, pays an evaluator they don't think is ordered in case they want to backdoor out, then subpoenas records that show nothing. The medical records show nothing. Then they tell you that they think there's drug use, despite the fact that they saw the records that the drug screens are clear. And now they say, okay, well, she's broke. Maybe that's how she uses drugs. It's a stretch at the best. But if it's a stretch at the best, open it up for both sides. Because
why shouldn't I open it up for both sides?
Good. I didn't know that. I'm following the rules. So if it's opened up for both sides, that I'm going to make a motion to amend my pleadings, and if they say the doctor isn't appointed, then he isn't appointed.
Is there any reason why you shouldn't open up discovery for both sides?
Well, the only reason I can think of, Your Honor, is that we have brought before the court a new development that is relevant to an existing issue. We didn't have to plead what we thought all the evidence might be in connection with our petition to modify. All we had to do was provide notice pleading, which we did. This issue is relevant to the fundamental underlying question under our petition to modify custody in this case. And that's the issue of whether the mother has a substance abuse problem that's affecting her ability to parent the minor children.
And I agree. I'm just wondering, is there a reason why I shouldn't allow them to issue any subpoenas that may respond to this newly discovered evidence?
You
If
know,
there is, because I think you'll find out once you acquire the subpoena information, correct? Or at least some of the questions you have may be answered.
I suspect that we will have some questions answered once we get this financial information, but I'm not aware of anything that any issue that respondent has raised, any newly discovered issue that needs discovery. If there is, we're happy to consider talking about stipulating to allow them to do it, but, you know, at this...
I'm not either. I think what I'm thinking of is just to allow her an opportunity to issue any subpoenas that she may think responds to whatever information you get. If she thinks there's something missing or there are additional documents that would explain something, I'm just trying to be as fair as I can to allow her a period of time to issue any subpoenas, at least open discovery to that narrow issue that you've now newly discovered information, and allow her a period of time to respond.
Certainly, Your Honor. These documents, however, they're documents within her control, so I don't know why she'd need to issue a subpoena to get them. But if there is something maybe related to Dr. Livingstone's opinion or expected opinion or underlying data, I think that's probably fair.
Well, I'm taking their word for it. She's dead broke. I'm filing a petition to modify this afternoon regarding alimony. So then I'll be entitled to subpoena anything I want. But the door swings both ways. What you just heard is we get to do what we want, but we'll give her permission to see if she gets to subpoena anything. That's not the way this process works. And if I was following the rules to my detriment, well, then I know not to. But then I would come here and you'd say, the rules are the rules. Discovery was closed over a year ago. You will follow the rules.
But again, what the rule says, Ms. Playclock, is Rule 26 indicates that discovery can be reopened if there are newly discovered issues.
Correct, but you have to do it.
That's what counsel argued.
No,
He's
he
saying
didn't.
There's some newly discovered issues.
Yeah.
Based on this bankruptcy, they want to inquire. They may be 100% wrong, but certainly,
Your Honor, I'm with
based
you.
on newly discovered issues, Rule 26 allows a party to reopen discovery and seek information based on what they've learned.
I agree, Your Honor, but
So
the
they
problem...
would be complying with the rules, would they
But
not?
this distinction is critical. This is newly discovered information that they told you was the basis for their issuing the subpoenas. I agree with all that. The problem is you can't just write yourself in order. They had to file a motion, newly discovered information. I want to open up financial issues. Then you would have said yes, or I would have said yes, go along with it. But they didn't do it that way. They just told you they had this for a few months. Then they said, okay, I'll subpoena stuff out of time. You have to ask for the motion before discovery closes, or it has to have been newly discovered. They didn't share any of that information with me. They didn't file a motion with the court, and they got here and they're explaining why they use self-help to violate the rules. If there is no order, there is no allowance. So they didn't have permission to do this. Now they're seeking permission based on their statement to you of newly discovered evidence. I'm with them. Then they have to file a motion. Newly discovered evidence can reopen discovery. But they didn't do any of that. Then they come to seek permission for what they haven't procedurally followed, not one of the rules. They got past that they didn't have to meet and confer. I'm okay if that's the rule in this case. None of us have to meet and confer. Just let me know. But they didn't follow the rules. Had they filed the motions, I would have stipulated. But this is the first time I saw it, and okay, my client didn't tell me she went bankrupt. Now I know. But the rules, that's why they're called rules. And if the rule in this case is we can do it, I'm okay. If it's we follow the rules and they had to file the motions, they didn't. If you're going to rule they didn't file the motions, but I'm going to let them do it, I'm okay. I'm on this side. I'll follow whatever you say. I just want to know what they are. Because they can't open discovery because they have in their head something new.
You're repeating your argument, but...
Well, I apologize.
So why shouldn't I require you to file a motion under Rule 26 26 for newly discovered, because I think she's correct. There's been no motion to open discovery based on newly discovered evidence. You just issued the subpoenas.
Your Honor, in our mind, we issued these subpoenas again in connection with the underlying data and facts with respect to the anticipated opinion of Dr. Livingstone, which would make this part of expert discovery. And in fact, Your Honor, there's been no notice of event due dates entered in this case. I could speculate as to why that is, but we've had a lot of procedural goings-on in this case that have delayed it significantly.
So has there been no discovery cutoff issue?
No.
And in that case, Your Honor, we
there's-
follow Rule 26. That's the rule. If we're not going to follow it, then we issue an order that says we're not going to follow it. Absent an order, discovery closed a year ago.
So let's say that I require them to file a motion of newly discovered evidence. It seems to me that this is newly discovered evidence. I would grant the motion.
And Your Honor, to the extent that the court sees this as us pursuing new fact discovery, I make the motion right here, right now. Please reopen.
Well, we can't do that orally.
Please reopen.
He needs to file a written motion so that if it goes up on appeal, that it doesn't become, oh, well, I said it sometime in court, because that's what we just heard about the custody
Well, we're
evaluator.
certainly making a record for the Court of Appeals.
And
You
records,
can file an oral motion or a written motion to open discovery based on this newly discovered evidence. I understand your argument. I'm asking him to comply with it.
And I just heard counsel say that if we'd asked her before we issued the subpoena, she'd have said, fine, so
no,
why
I
is there
said
a
I would
problem
have
now?
stipulated in writing, so we all know what we said. I asked for a motion in writing so that I know the basis for your statement, because it might not be this basis. I want to see it in writing. I'm entitled to do that.
Does the court have further questions for me?
No. So what I'm going to do is I'm going to require that you file a written motion to open discovery based on a newly discovered issue. Ms. Blakelock will have, I think, what's the period, 7 days to respond? Or is it
14.
14 days to respond. I'll rule on that motion. And part of the motion should be whether or not the court is granting the request to issue the subpoenas. So if we don't have a second motion, so the motion would be to reopen discovery first, and second, for the court to issue an order that the subpoenas be allowed to be issued and responded to. So we've ruled on that, or at least we're going to rule on that issue. The subpoenas to financial institution under advisement, the subpoena to Dr. Livingstone. I'll try to get that out quickly. Hopefully this week. And then I've already ruled on the objection, denying that objection to the subpoena to Dr. Taylor based on the previous order. I assume that the bankruptcy proceeding documents are public documents.
That's a public record, Your Honor. It's right off the district court, bankruptcy district court's website.
My objection wasn't in the nature of its existence. My objection was in the nature of surprise. It might exist, lots of documents exist, but that doesn't mean I've seen them. I never saw this before they slapped it over here
Well, I
this
think
morning.
generally the case law is that if you have joint access, you can reach a public document, then there are some that they don't have to provide. They're there, public documents, and you can reach those as long as they provide them later on discovery if they were going to admit them. All right, I think we've at least decided the issues, how we're going to go forward. Let's take a 5-minute recess. I'd like to see both counsel back in chambers if I could, just for a few minutes.
All rise.
simple thing, here's what our issues are.
So, Your Honor, I think that's correct. There is one pending motion that the Commissioner didn't want to hear, wanted to send to you, but we would like an opportunity to try and resolve this case, so we kind of want to table that, and so we want to, I guess I think we're both in agreement that we ask the court for a little bit of time to see if we can mediate this and come to a resolution, and then
You want to set it for another status conference down the road?
we'll do that.
I think we do, Your Honor. We've sold the house, so one big issue's out of the way. And opposing counsel and I, even if we can't agree, want to try and get to the smallest number of items we can to have tried. So, and if we can get it down to one or two, I think we both kind of stipulated that we've agreed to do discovery on this, on the issues that just limited if they're before the
I
court.
think that would be great.
And then we'll,
the least amount of issues you can narrow down to, the better.
and we have a sum certain that's being held in my trust account. I've documented that. It's there. Those funds won't be released absent stipulation of the parties or court order, and that's just where we're at on that one.
All right. So, what amount of time do you think you need to number one, narrow down issues, and number two, have an opportunity to mediate if you decide to do so? You want 30 days, 60 days, 90 days? I'm up for your suggestions.
Let's try.
Because I think I can get
Because
called
and Sandra would do this with him on your phone if you want to try her. Yeah, we're going to try, we have a mediator that will work with us by phone, for Mr. Bryant. So, and we'll call and check with her. Maybe what we could do, Your Honor, is if we need another hearing date, we might not need another pretrial, because in our mediation, if we don't resolve the issues, we can use that to draft a pretrial order and then just submit that to you. So, and
My
then,
thinking was, though, that if you decided to go to trial,
Then
I'd
we'd have
rather
to
have
go- yeah.
another pretrial conference so we can set some motions cut off.
Sure.
And,
sure, yeah, that's fine.
is this going to be a jury trial or a
No,
bench
no,
trial?
it's just a divorce.
So it's a,
If we let the jury in on divorces, all hell will
yeah,
break
that's
loose.
good. So it'd be a bench trial. All right, so we're not going to set a date, and you can come back to the court when you're ready to set a pretrial conference if needed.
If we do, we'll call on from mediation and get a date. How's that
Okay.
sound? That way we'll be together.
The only thing I wanted to have you remember is there's a 90-day, isn't there a 90-day period, Nicole, where on the court's own motion, if there's been nothing filed,
Okay.
so you just want to remember that.
We
that
will.
if we go to 90 days, then the court's own motion will be in order to show cause. It's just an automatic thing.
Okay,
Okay.
we won't go past that then.
We won't.
Okay, thank you.
All right, anything else? All right, thank you to both of you. Have a great day.
Thank you.